Good evening, class. So tonight we're going to cover Chapter 8. For those who have the book, for those who don't, you can follow along. We're going to be talking about agency. So tonight we're going to be learning about your livelihood, basically, agency, and what it means to be an agent. So what we got in Chapter 8, or just in general, when we talk about agency, first we have some terminology we have to learn. So we start off in Chapter 8, which is going to be right at the beginning of 8-1. We define what a broker is. So it says a real estate broker is any individual who for consideration sells, buys, rents, exchanges, or negotiates options on real estate or real property. Okay, so now we know what a broker is. And many of your offices, when you're out there as real estate agents, many of your offices, you're going to be dealing directly with the broker owner of the office. So you'll be working for a broker owner, and you'll be a salesperson with your license. Okay, so on we go. The laws of agency. So the law of agency is that part of contract law that governs the relationship between a principal who hires the agent, person who hires you, in other words, to represent them. Okay, and just in general, we have a principal who is the person who's doing the hiring, who's going to hire you as an agent. That would be the buyer or the seller. Okay, and that's the individual that hires. And the agent would be the broker, and you as the salesperson. Correct? Correct. All right. And then the relationship that is created between the two is called agency. Now, as it says in general, an agent must act in the best interest of the principal. So you must act in the best interest of the person that hires you, who would be the principal, the buyer, or the seller. And that relationship, that responsibility that you have is a fiduciary relationship. That is one of the highest forms of trust that can be between two individuals. A fiduciary is someone of high trust. Okay, and we'll talk a little bit more about that later on. So, moving down, just jumping forward a little bit. So now we go into types of agency. And so under the types of agency, there is a general agency, and that's an agency relationship covering a broad range of matters. So you would be an agent for somebody doing a variety of different jobs for them. That's a general agency, as opposed to a special agency, which is not the government, right? A special agency is an agency where an agent is hired to perform an individual or specific act. So more narrow in scope, not so many tasks. You won't be covering so many tasks for your principal. And then the next type of agency would be a estoppel agency. And this is an agency established when a third party has a reason to believe that due to the actions of the two parties, that the agency relationship exists. What I usually say to the class is, maybe I'll pick somebody in the class and I'll say, you and I have been we're friends first, and I'm your principal, the person who hires you. You're my agent, and we're friends first. If we don't have anything formal because we're friends, right? You don't have any type of a formal relationship or a formal agreement, a contract, but you're showing me properties because I'm trying to buy a property. And because of our actions showing up together at the property, the other listing agents, the listing agent is the agent that's going to be listing the real estate for sale. The listing agent believes you, as my friend, to be my agent. And so therefore, agency can be asserted at that point. It's a estoppel agency. Next type of agency is facilitator. And that is basically a broker who does not represent either the seller or the buyer, but is kind of the middleman, puts the parties together, supplies the contracts, and the deal happens. The facilitator still gets a commission. That's how you get paid. But the facilitator does not formally represent the buyer or the seller in the transaction. All right, and then there's a legal document that's talked about next, which is a power of attorney. That is a form of agency. And it's a legal document that authorizes another individual to act on behalf of you or the person who makes the power of attorney. The person who is appointed as the agent is called the attorney in fact. So this is just sort of legal terminology. That's the name of another name of the agent under the power of attorney. All right. Okay, so the creation of agency now is what your book will talk about. And so how is agency created? Well, it can be expressed or implied, kind of like on our contract segment, right? An expressed agency is a mutual consent between the principal and the agent. It's usually in writing, but it can be oral as well. All right, and so the terms are expressed. The scope of agency, the job of the agent is detailed. Either they discuss it or they put it in writing. That is an expressed agency, as opposed to an implied agency, which once again we talked about what an implied agency is. It basically is the principal and the agent have not agreed on a formal agency relationship, but their actions indicate that there's an agency in existence. And that was the example I gave you with you as my friend, and because of our actions, people assume that there's an agency relationship. Now, whenever there's agency, whenever you're an agent for me, for instance, I hire you, there is the whole method or whole concept of imputed knowledge. Now, the knowledge by an agent is that is binding on the principal due to the principal-agency relationship. So if you are out on the market and you become aware of something, or you make a representation to another party when I don't even know about it, you're binding me to knowing that information that you've presented or heard. So it's imputed knowledge because of the agency relationship between the two of us. That's what they mean by imputed knowledge. Okay, the principal does not have to know firsthand. Okay, and the knowledge is imputed to me. It's actually given to me even though I don't know it. All right, so we covered the general types of agency, okay, and we also talked about how agency is created. We talked about imputed knowledge. Now in Massachusetts, agency has recently changed. So what I'd like to do is to talk about the agency disclosure form, because these are forms that you're going to be seeing in everyday life. And so the agency disclosure form is good at this point to review because it actually talks about the types of agency in Massachusetts. So with no further ado, let's jump right up to our agency disclosure form. Let me blow this up a little bit for you. So here we are. Now this, you're going to hear this over and over again, by the way, before the end of class. At first personal meeting to discuss a particular piece of property. Those are components, okay? At first personal meeting with a customer, with a principal to discuss a particular piece of property, piece of real estate. You have to put this disclosure form down in front of your client, okay? And this is going to talk about different issues. So as it says here, this disclosure does not provide you, the consumer, this disclosure is provided to you, the consumer, by a real estate licensee listed in the disclosure. Okay? All real estate licensees must present this form to you at first personal meeting with you to discuss a specific piece of property. You see that over and over again. Consumer information and responsibility. This is the responsibilities of the consumer. If you are a buyer or seller, you can engage a real estate licensee to provide advice, assistance, and represent you as your agent. A real estate licensee can represent you as a seller agent, right, which we'll see in a second, or a buyer's agent, and can assist you as a facilitator. We already talked about that. All real estate licensees, regardless of the working relationship with a consumer, must, by law, present properties honestly and accurately and disclose known defects in the real estate. So we'll talk about that a little later when we get into 93A. Okay, but it also says here that what the real estate agent is not responsible to do. Okay, the consumer is responsible for some of their some of the obligations in a contract. And, once again, they talk about, well, if you need a tax professional, go get one, consumer. If you need insurance information, go get someone who's versed in insurance information. If you need legal representation, go get an attorney. In essence, what they're saying is you, as a real estate agent, you're not responsible for that information, nor could you advise folks in those areas. Okay, down below we'll say check the box. Seller or buyer receiving this disclosure is hereby advised that the real estate licensee named below is working as it can be a seller's agent, a buyer's agent, or a facilitator on this form. Okay. And there's also something called designated agency. So now what is this all about? Well, if you flip over, if you have this piece of paper, the hard copy in front of you, you flip it over, and there are the types of agency. So the types of agencies present, the seller's agent. So there's full responsibility now to you as the seller's agent. You have all of the duties, which we're going to go over in a minute, which are called your fiduciary responsibilities to your client. So as it says here, a seller can engage the services of a real estate licensee to act as a seller's agent in the sale of a seller's property. So you're called the listing agent here because you are the seller's agent, all right? So it's seller's agent, listing agent, they all mean the same thing. This means that the real estate agent represents the seller, who is a client, which we talked about. The principal is another name for client. The agent owes the seller, client, undivided loyalty, reasonable care, disclosure, obedience to lawful instruction, confidentiality, and accounting. This is a definition, folks, of a fiduciary responsibility, which we're going to go over again. There is a section in your book that defines all of these. The agent must put the seller's interests first and attempt to negotiate price and terms acceptable to their seller client. The seller may authorize subagents to represent him or her in marketing its properties. I will talk to you live about subagency. This was actually the cause of a lot of problems in Massachusetts where the laws had to be changed. However, the seller should be aware that the wrongful act of a real estate agent or subagent may subject the seller to legal liability for those wrongful actions. Well, that's kind of the idea behind agency, right? They're acting on your behalf, but they also obligate you to things that you may not be aware of. Now, the definition of a buyer's agent, now you're representing the buyer, you're taking the buyer around to show him properties. It's the same exact definition as the seller's agent. All of your obligations are the same because you are the buyer's agent, but you're just representing the buyer to find properties. But you do owe the duty of undivided loyalty, reasonable care, disclosure, obedience to lawful instructions, confidentiality, and accounting. And it defines the same thing. It's the same provision over again, just applies to the buyer. Moving on down our disclosure form, there is the facilitator. So what does that mean? Try to get this down off my screen here. So facilitator. When a real estate licensee works as a facilitator, the licensee assists the seller and or the buyer in reaching the agreement, but does not represent either the seller or the buyer in the transaction. The facilitator and the broker with whom the facilitator is affiliated. Now, what they're talking about here is if you're the facilitator, let's say, for instance, I'm the broker owner of the office. You work for me as a salesperson. You're a subcontractor under me as a salesperson. So what they're saying to you here is you would be the facilitator in the transaction because you brought both parties together. I am your managing broker. All right. So it says the facilitator and the broker with whom the facilitator is affiliated, you and me, owe the seller and the buyer a duty to represent all real estate property honestly and accurately by disclosing no material defects. And owe a duty to account for funds. But that's it, folks. None of these other duties above, I wish that would stop coming down. None of these other duties above apply because they can't. In the reality of the situation, you're a facilitator. You can't have something and hold it confidential. You can't be obedient to one side because you're not representing either. You can't, you have to really be reasonable with your care, but you don't have undivided loyalty. So there are some of the fiduciary responsibilities they get whittled away. They lessen as your responsibility or as your representation kind of goes this way, right? Like a shotgun. It goes out because you're representing both parties. So you can't have this many obligations to one party. It just isn't possible. Now, in the relationship between, in my example, I'm the broker owner and you're my agent. In the relationship between us, my agency with your client follows you. So at that point, I'm a facilitator as well as you, and that's the way we conduct ourselves in that transaction. Now, you can have designated agents. Now, usually in this instance, what will happen is the buyer and the seller will come in, and I'll give you the same example. I'm the broker owner. You might be working for me as a salesperson. I might have somebody else in the office working as a salesperson. That person has a buyer. You have the seller. Everything is in-house now, okay? And what I might say to you, because you have the seller, is you're a designated seller agent. And I might say to the other agent in my office, you're a designated buyer's agent. So that means that both of you separate, and that inside the office, inside the house, there's a separation. Right? You have the seller side, the other party has the buyer side. What happens with me at that point is my relationship does not follow you. It severs because I have to be able to watch both parties. It's in my house, right? So I have to watch the buyer's party and I have to watch your party, which is the seller's party. So the relation they talk about in this provision, in this section, they talk about the relationship between you and me with the other real estate agent that works for me. So a real estate licensee that is designated by another real estate licensee, appointing or designated agent, okay? You'd be designated seller's agent in this instance. To represent the buyer or the seller, provided the buyer or the seller expressly agrees to such designation. So your client, who would be the seller in this instance, would have to agree to you being appointed as a designated agent. They would be signing this disclosure and probably another one you'd put down in front of them. The real estate licensee, once so designated, is then the agent for the buyer or the seller who becomes the agent's client. So the buyer or the seller becomes your client. The designated agent owes the buyer, client, or seller client undivided loyalty, reasonable care, disclosure, obedience to lawful instruction, confidentiality, and accounting. This is all, once again, the full definition of a fiduciary responsibility. You have all your full responsibilities to your client. In the same house, the other agent that works for me will also have the full scope of fiduciary responsibilities. The agent must put their client's interest first and attempt to negotiate a price in terms acceptable to their client. No other licensees affiliated with the same firm, with my office, right, represent the client unless otherwise agreed to by the client. In this situation, where the appointing agent designates the other agent to represent the seller and the agent to represent the buyer in the same transaction and in the same house, right? In the same office, as we just said, then the appointing agent, me, becomes a dual agent, which we'll talk about in a minute. I become a dual agent. You're still designated to your client, and the agent that works for me representing the buyer is designated to their client. It's severed. Okay, our relationship is changed. I normally follow you, but not in this instance, okay? Consequently, a dual agent cannot fully satisfy the dual duties of loyalty, full disclosure, obedience to lawful instructions, which is required of a seller or buyer's agent. So it's saying my responsibilities lessen because my scope has broadened. I have to cover two parties, you and the other agent. So I can't realistically satisfy the duties of loyalty, full disclosure, and obedience because I'm the broker owner, and now my relationship has become a dual agent. Hopefully that's clear. Which is so the only your designated agent represents your interest. Written consent for designated agency must be provided before potential transaction is identified. But in any event, no later than prior to the execution of a written agreement. So before the written agreement occurs, the purchase and sale agreement, that agency has to be plunked down in front of your client, or that disclosure has to be plunked down in front of your client. And then the last one is a dual agent. What is that? Well, I just kind of explained that to you. A real estate licensee may act as a dual agent representing both the buyer and the seller. So in the office, you might know a buyer and you might know the seller. You might bring them together and you might act as a dual agent. When you do that, you get the what we call a double hit on the commission. That means you collect the full commission. If it's 5%, 4%, you get the full thing. That's not a bad take, okay? So you're representing both the buyer and the seller in transaction, but only with expressed and informed written consent of both the buyer and the seller. So both parties that you know have to sign a consent form. A dual agent shall be neutral with regard to conflicting interests of the buyer and the seller. So in some respects, the dual agent is neutral. Consequently, a dual agent cannot satisfy fully the duties of loyalty, full disclosure, obedience to lawful instruction, which is required by a seller or buyer's agent, because you know both parties. It's not possible for that to happen, right? A dual agent does, however, still owe a duty of confidentiality of material information and accounting for funds. Okay, so there are two duties that you will have. Written consent for dual agency must be provided before any potential transaction is identified, but in any event, no later than the execution of a purchase and sale agreement. Okay, so those are your general types of agency, all explained on the agency disclosure form in Massachusetts. Now, as we said, when you have a principal and you're working as the agent, there are the duties of an agent. And we just went over them briefly on that disclosure form. But what are they? So a full fiduciary relationship that you might have with a buyer or a seller, if you're the buyer's agent or the seller's agent, would be obedience. And the acronym is OLDCAR, okay? Obedience. An agent must obey the principal's instruction so long as it does not violate the law. Okay? An agent must express loyalty. Agent must act in the best interest of the principal, even though it's not in the best interest of the agent. All right? So you might, for instance, receive an offer for your seller that's lower than other existing offers. You still have to present that offer to the seller because it might still be stronger in other facets, whether it's cash or waiving home inspection. Disclosure, duty of notice. An agent must keep a principal informed. Well, that makes sense. Confidentiality requires an agent to keep confidential any information about the principal client. And accountability. An agent must account for all funds handled by him, must maintain a separate account for all deposits. There must be no commingling of funds. And then the number 6 is reasonable care and diligence. A reasonable degree of care, skill, and care. Okay? So that, in a nutshell, is the introduction to agency. I will be talking about other facets of agency and some of the problems that happened in the past about agency to help you better understand it. But that is the beginning of agency. I hope you enjoyed it. And I look forward to talking to you in the next segment.